What is an executor? In making a will, you are required to appoint an executor. The executor is responsible for seeing that the terms of the will are carried out. They execute your intentions. The executor of your estate will be required to comply with the various laws and rules that govern the administration of deceased estates. Who should be my executor? Executors can be personally liable for any mistakes made in distributing assets to beneficiaries, so it's important to get it right. You need to appoint someone who is honest, trustworthy, businesslike, and likely to outlive you. They may also need to be able to devote time needed to the task and, perhaps for convenience, live nearby. You will need someone who is likely to be impartial in the event of any dispute among your beneficiaries, and who can carry out other tasks appropriate to your special circumstances. For example, choosing schools for your dependent children. The main duties of an executor are to be responsible for the burial and cremation of the deceased body, to prove the will, in other words, to obtain probate, to collect all debts owing to the estate, to claim any life insurance, if required by the terms of the will, to convert non-cash assets into cash, to collect investment income, to lodge income tax returns, to pay any required income tax, to pay, in proper order, all debts owing by the estate, to protect and insure the assets of the estate, to administer any trusts set up under the will, to pay any specific legacies, to distribute the remainder of the estate. It is generally desirable to ask the proposed executor or executors before naming them in order to establish their willingness to act. Given the personal nature of an executor's responsibilities and the sensitive time in which they are required to act, it is important to consider the personal as well as practical implications of selecting your executor. Should I appoint my solicitor as my executor? Considering our aging population with increasingly complex personal, financial, and business affairs, you may consider appointing a professional, such as a solicitor or a professional trustee, to be your executor. The advantages of appointing a solicitor include impartiality, professionalism, experience, and knowledge, efficiency, and liability. So, what exactly is the role of the executor? Arranging the funeral is usually left to the executor of the will, and they can access the deceased person's assets to pay for the funeral costs. In relation to the deceased body, it is owned by the executor or next of kin if there is no will or no executor appointed. An executor is responsible for finding the will, getting the death certificate, ascertaining the deceased's assets and liabilities, assessing the value of the deceased assets, obtaining probate if required, paying the deceased's debts, income tax, duties, and funeral expenses, distributing the assets according to the terms of the will. Executor frequently asks questions. Can I renounce my role as executor? While many people may see it as a compliment to appoint a friend or relative as executor, they often fail to consider what they are asking is a huge task for someone who may be grieving and distressed. Being an executor, even for simple estates, can take a considerable amount of time. The skills required can also be very difficult for an executor who does not have relevant experience in law, accounting, business management, or finance. As executor, you may be liable for your management of the estate. Just because you have been nominated as the executor doesn't mean you have to accept. Taking on the responsibility may not be the right thing for you, and it is unlikely that the person who nominated you would have wanted to put you in a stressful situation. Do I need probate? Banks and other asset holders such as share registries and superannuation funds often require probate before releasing or transferring assets. This may depend on the value of the assets, as some may be prepared to release lower value amounts without a grant of probate. A grant of probate will be necessary if real estate is owned in the deceased's sole name or as a tenant in common with someone else. If the deceased owned an asset as a joint tenant with another person, that asset automatically passes to the surviving joint tenant, and a grant of probate would not be required for that asset. It is strongly recommended that an executor obtains legal advice before proceeding to deal with an estate, because they can be personally liable in some circumstances, including, for example, if a debt is not properly accounted for or if assets are not properly distributed to beneficiaries. Who may contest the will? After a grant is made, the will becomes a document of public record and a copy is available from the Supreme Court to any person upon payment of the appropriate fee. While a person is entitled to leave their assets to anyone they wish, there are a number of grounds on which the distribution of a person's estate can be challenged. If you'd like to know more or you need help in relation to wills and estates law, please contact us. You're welcome to email us at info@quinns.com.au, call us on 1300 Quinns, or visit our website www.quinns.com.au. We'd love to get your feedback in relation to Quintessential TV, so please like, comment and subscribe. We look forward to seeing you all again next time. Bye for now.